HMC Daily News with your host, Penelope Barrett.
Hello, and welcome to our viewers joining us today. I'm Penelope Barrett for HMC News. Today's top story is a new MEAC opinion. We'll discuss what this means for Florida mediators statewide. An opinion was requested regarding confidentiality today, specifically regarding attorney conduct in consumer debt mediations. The question posed is as follows. Is it consistent with mediation ethics and Rule 10.360 for a party representative, like a coverage attorney, to suggest that information shared in mediation may be repeated to the party being represented outside the mediation? The question stated the following important facts in their scenario. Quote, in these cases, it is common for plaintiff coverage attorneys to advise defendants not to disclose certain personal financial information, such as recent lottery winnings or inheritance, saying something to the effect of, don't tell them anything you don't want us to repeat to our client. These warnings are often given during mediation. My understanding is that under Rule 10.360A, all communications made during a mediation are confidential and may not be disclosed outside of the mediation. However, these attorney warnings appear to imply that anything shared by the defendant may later be used against them in settlement negotiations or litigation. This may discourage parties from participating openly in mediation and erode trust in the process. The author relied on the following laws: Florida Statutes, Section 44.401 through 406. Florida Rules for Certified and Court-Appointed Mediators 10.200, 10.220, 10.360A, and 10.910. And a prior MEAC opinion 2010-002. MEAC Committee Chair Haddis Stagman wrote the official opinion on this matter. In summary, it is consistent with the standards of professional conduct for a mediator to share or to allow a party representative as a mediation participant to share mediation communication with a mediation party or the party's counsel, even if the party or counsel is not present at the mediation session. The MEAC opinion then explains why this conduct would be allowed in this particular scenario by discussing the rules and laws presented by the author. To talk on this further, we're turning to our expert, Luke Jones. Luke, can you tell us a bit more about the laws contained in this opinion?
Yes, Penelope. First, let's address Florida Statutes 44.401 to 406, which apply to any mediation. 44.402 covers any mediation required by statute, court rule, court order, or administrative order. In this case, pretrial small claims mediations are court-ordered. It also covers any mediations managed by Supreme Court certified mediators. All Florida court pretrial mediations are conducted by certified mediators. Florida Statute 44.403 defines several areas under mediation to avoid confusion. It defines a mediation communication, mediation participants, and mediation parties. Mediation communication can be oral, written, or nonverbal conduct by a participant during the mediation or prior to a mediation. Here they are confirming that this was in fact a mediation communication made by the attorney in question. A mediation participant is a mediation party or person who attends a mediation. With this, MEAC is also agreeing that everyone who attended the mediation, including the attorney's client who was not physically present, is a mediation participant under law. A mediation party is a person who is a named party or is a real party in interest if the matter was brought in a court of law. Here MEAC clarifies that the coverage attorney's client is also a mediation party because they are named in the dispute paperwork.
It seems that MEAC is giving background to their opinion with supporting law. Is that correct?
Yes, Penelope. This is how MEAC likes to lay the groundwork for the opinion. First, they make sure that a mediation did occur, that the parties were all present, and the acts were during mediation. MEAC then discusses the distinct acts questioned by the mediator. Here MEAC dives into Florida Statute 44.405, which talks about confidentiality and its exceptions. Here MEAC is reminding the mediator that there are no legal exceptions to confidentiality under Florida statute except as stated here. They also discuss the confidential information discussed with an outside participant. 44.405 states confidential information may be disclosed to another mediation participant or participant's counsel. Because MEAC has stated that the attorney's client is a mediation participant, this communication is allowed. MEAC doubled downs here by stating, in fact, mediation communication may not be withheld from a mediation participant or participant's counsel, and a participant may not prevent the opposing party's attorney from receiving mediation communication. MEAC cites the 2010-002 opinion from 2010 as additional support, which tells us that nothing has changed in the last 15 years. The recently updated Florida rules for the certified and court-appointed mediators were also discussed, Penelope. They reference Rules 10.200, which reminds the submitting mediator that MEAC's powers only apply to certified and court-appointed mediators, and 10.220, which reminds the mediator that their role in mediation is to reduce obstacles to communication and assist in the identification of issues, and 10.360, which discusses confidentiality in particular. In conclusion, MEAC stated, "It is not the mediator's duty or authority to enforce provision of the Florida Statutes Act as long as the mediator conducts the mediation consistent with the standards of professional conduct of mediators. It is consistent with the standards of professional conduct for mediators, including Rule 10.360, for a mediator to allow a party representative, as a mediation participant, to share mediation communication with the mediation party being represented or the party's counsel, even if the party or party's counsel is not present at the mediation session."
It looks like MEAC made a line in the sand regarding attorneys talking with their clients who are not present during a mediation. That's understandable.
Yes, it would be very difficult to get small claims and family law cases done in Florida without this opinion from MEAC, especially considering online mediations.
Thank you for your insight, Luke. You said the rules were recently updated. Can you tell us when that update happened?
Yes, the rules were updated January 1st, 2025.
Thanks again, Luke. As a reminder, MEAC has the power to provide opinions subject to Rule 10.910. MEAC is not authorized to give legal advice or establish best practices for mediators. Each opinion is based on the specific facts of the scenario presented. If you have a question for MEAC, please send your question to Florida Dispute Resolution Center, Supreme Court Building, 500 South Duval Street, Tallahassee, Florida, 32399. You may also email MEAC at the email shown on your screen. MEAC asks that you give details and include any rules you think are related to your question. Written opinions may take up to 120 days and are posted on the DRC's website. MEAC only considers written questions related to Florida certified and court-appointed mediators who are subject to the FRCCAM. You can find MEAC opinions on the Florida Court's website. That was Daily News. I'm Penelope Barrett. Thank you for watching. Good night.